FBI is fighting to keep some records concerning Nigerian President Bola Ahmed Tinubu from being fully released to the public. And now, a lawyer representing detained indigenous people of Biafra leader Nnamdi Kanu says there may be several reasons behind the American agency's decision. But there is one question at the center of this controversy. What exactly is the FBI trying to protect? And why does the agency believe some of these records cannot be explained publicly? The latest development comes after the FBI asked a U.S. federal court for permission to explain under seal why certain information should remain hidden. According to the agency's position, releasing some of the materials could endanger individuals and expose sensitive law enforcement methods. That request has attracted significant attention because the records relate to a long-running investigation dating back decades. Barrister Aloy Ejimakor, special counsel to Nnamdi Kanu, has now analyzed the FBI's argument, and his analysis raises several possibilities. But before we get into those possibilities, there is something extremely important that must be made clear. The FBI's decision to withhold or retract records does not, by itself, prove that the records contain evidence of criminal wrongdoing by President Tinubu. That distinction matters. The dispute is primarily about access to government records under America's Freedom of Information Act, commonly known as FOIA. Under FOIA, government agencies are generally required to release records requested by members of the public, but Congress created several exemptions that allow agencies to withhold sensitive information. One of those exemptions is Exemption 7F. Under this provision, law enforcement records can be withheld when releasing them could reasonably be expected to endanger the life or physical safety of an individual. And according to Ejimakor, the FBI does not necessarily have to prove that somebody will definitely be attacked or harmed. The legal standard is whether there is a reasonable expectation that disclosure could create such a danger. That distinction gives the FBI considerable room to argue that certain information should remain protected. So what could the FBI possibly be worried about? Ejimakor identifies several potential explanations. The first involves confidential informants and cooperating witnesses. Historical investigative files can contain the identities, personal information, or other details concerning people who provided information to investigators. If such information were released, the FBI could argue that those individuals or even their relatives could face retaliation. And that argument becomes particularly relevant when the records concerned organized criminal investigations. Even though the investigation dates back to the 90s, the FBI could still argue that some of the people connected to it are alive today. The second possibility involves law enforcement personnel. Investigative documents can contain the names of agents, officers, and other personnel involved in the investigation. The FBI could argue that publicly identifying some of these individuals could expose them to harassment, intimidation, or even physical attacks. Then there is another issue: investigative methods. Some records may reveal how investigators obtain information, how sources were handled, or how sensitive operations were conducted. The FBI could argue that releasing those details could expose people who assisted investigators or reveal methods that remain sensitive even decades later. And this is where the FBI's request for an ex parte review becomes significant. In simple terms, an ex parte proceeding allows one side to present sensitive information privately to the judge. The public does not necessarily get to see the entire argument. According to Ejimakor, the FBI's request suggests that even publicly explaining why certain information must remain secret could itself compromise the interest the agency is trying to protect. Think about the dilemma. If the FBI publicly explains that a particular document is being withheld because it contains information identifying a particular source, the explanation itself could potentially provide clues about that source. So the agency's position is essentially that some of its justification has to remain secret because revealing the justification could undermine the protection. But that naturally creates another question. Should the public simply trust the FBI's explanation? That decision ultimately belongs to the court. The judge can examine the material privately and determine whether the agency has a legitimate legal basis for withholding it. And that is important because the FBI does not have unlimited authority to classify information simply because the information is embarrassing or politically sensitive. The agency must fit the information within one of the exemptions provided by FOIA. And that brings us back to the broader controversy surrounding Tinubu. The records have attracted enormous interest because of historical allegations and investigations connected to the Nigerian president. For years, questions have circulated about what U.S. authorities knew, what information they collected, and what the historical investigative files actually contain. But it is critical to separate allegations, investigative records, and proven facts. The existence of an FBI file does not automatically mean that everything contained in that file was established as true. Investigative records can contain allegations, leads, interviews, intelligence, and information provided by third parties. Likewise, the withholding of information under FOIA does not automatically mean that the withheld material is damaging to the person named in the records. It could simply contain information that the government believes could expose a source, an agent, or a law enforcement techniques. That is the legal argument now before the court. However, Ejimakor believes the story will not end with permanent secrecy. In his analysis, he predicts that the records will eventually be disclosed, but he expects substantial portions to be redacted. In other words, the public could receive the documents, but large sections may be blacked out. And that creates an interesting possibility. The records could technically be released while still leaving many of the most sensitive details hidden. Names could disappear. Identifying information could be removed. Operational details could be blocked. And entire sections could potentially remain unavailable. Ejimakor's prediction is that what remains visible may have little political value. But nobody can know exactly what the documents will reveal until the court makes its decisions and the records are actually released. And that is why this case remains so significant. The debate is no longer simply about whether records exist. The focus has shifted to much more of those records the American government will actually allow the public to see. The FBI says there are legitimate law enforcement and safety concerns. Transparency advocates want greater disclosure. Ejimakor believes the record will eventually emerge, but with significant deductions. And the court now has to balance these competing interests. On one side is the public's right to access government records. On the other is the government's responsibility to protect confidential sources, individuals, and legitimate investigative methods. There is also a much bigger political dimension. President Tinubu remains at the center of intense public debate in Nigeria, and any additional information emerging from the U.S. government records could attract enormous attention. But that is precisely why caution is necessary. If the documents are eventually released, individual claims within them will need to be examined carefully. A reference to a person does not necessarily establish guilt. An allegation is not a conviction. A law enforcement investigation is not automatically proof of wrongdoing, and a redaction is not automatically evidence of a cover-up. Those distinctions will be crucial when the records finally become public. For now, however, the FBI is asking the court to allow it to make part of its case privately. And that means the public still does not know exactly what information the Bureau believes is so sensitive that even the explanation for withholding it must remain secret. So the question remains, what is inside this record? Are they protecting confidential sources? Are they protecting former or current law enforcement personnel? Are they protecting investigative methods? Or is there something else the FBI believes could create a serious risk if revealed? Those questions remain unanswered. What we do know is that the legal battle is continuing, and the final decision could determine just how much of the historical records concerning Tinubu will eventually enter the public domain. And when those documents finally emerge, the most important thing will not simply be what people claim they contain. It will be what the documents themselves actually say. Because in a case surrounded by political controversy, speculation can spread faster than facts. And the real test will come when the records are placed in the public domain and examined line by line. Until then, the FBI's secrecy argument remains a legal claim, not proof of what the records contain. I am Cassie Tony. Many thanks for watching.